What happens when two seasoned business leaders get together? They talk shop, of course. Sit back and listen in as Scott DeLong and Vince Moiso share from their experience around current issues facing executives, entrepreneurs, and their leadership teams. The CEO Podcast starts now.
Hey everybody, Vince Moiso here from the CEO Podcast. I'm here as always with Scott DeLong, and we have a special guest today, Andrea Paris. And before we get started on the topic, just want to remind everybody you can check us out on Apple Podcasts, on Spotify. We're on YouTube, so we'd love for you to subscribe to our channel on YouTube and follow us there. And we always want to hear from you. We want your feedback, and we love getting topics from our listeners. So you can reach out to us at scottandvince@gmail.com or just go on to the ceopodcast.net and you can reach us there.
And that includes critique as well. So it's not just questions and comments and suggestions for future topics, but critique us. We're good with that.
Yeah, absolutely good with that.
Yeah.
You know, I think we want feedback more than anybody.
Yeah. Well, when you're making the ratings on Apple, though, don't put the critique there. Put that to us personally, and just those 5 stars will look good.
Yeah. Well, speaking of which, we'd love to get more and more reviews. So if you are on Apple Podcasts or Spotify, would love for you guys to give us a rating for however you feel about us, and leave your comments there. Okay. With that said. I want to introduce Andrea Paris, and she is an attorney here in California, and she focuses very much on employment law, which is what our topic is today. And Andrea and I are in Entrepreneurs Organization together, and I had the privilege of listening to her speak not long ago on just giving updates around what you want to know in employment law. And I think, for the topic today, is if you are a California corporation, it is challenging, right? And we live... There's
actually several states that are challenging. New York is another challenging one, right? Sure. But we're here in California, and we have the California expert, so...
Well, that's what we're so essentially that's what we're going to focus on. Yeah. But I think that there are a lot of things that we're going to talk about today that certainly have application all over the country. Right. That being said, when you're talking about the more challenging states like California, which means they're very much on the side of the employee. Nothing wrong with that. I think California has done in a lot of ways a really, really great job to take care of the employee. When you're a small business, and Scott, most of our listeners out here, and we live and breathe in the small business space. When you're a small business, that can be challenging. They can also be costly. And we talked in our previous episode, we talked a lot about retention, employee retention, right? And some of the things that you can do to retain key people within your organization and even attract talent to your organization. And I think you have to have the legal aspect in mind. So we talked about in that particular episode, we were excited for this one because it was going to be a continuation of that conversation. So before we jump in heavy, Andrea, do you want to talk a little bit about your background, talk about your law firm, how people can get a hold of you? So we like to do that at the start.
Sure. Hi, everyone. My name is Andrea Paris, like the city in France. I have an employment law practice here in Orange County, California. Mm-hmm. And just like Scott and Vince said, California is a very challenging state. And so lots of really, really technical laws. And I really enjoy doing that. I especially love representing women at work. Mm-hmm. Whether it's as business owners or as employees as well. And so I get the perspective from both ends.
And so you do both sides?
Yes, I do. Interesting. And I get calls from both sides. And so, that's what I do. And you can get a hold of me at ap@andreaparislaw.com.
Love it.
Perfect.
Scott, what's your thought on this topic?
So my first thought is that, especially for the entrepreneurs out there and those that are just getting started in particular, that haven't come across the issues and problems, is that our ignorance does not excuse us under California law.
Absolutely. The rules are there. The default is that you are responsible for complying with the laws, mm-hmm. regardless of whether you know or you don't know. And so, a lot of times it's you don't know what you don't know. Mm-hmm. And so when I advise people who call, I always talk about 2 aspects. One is the legal requirements. And the reality is even the big companies, everybody's doing something wrong.
Sure.
And so you do the best that you can to educate yourself, maybe hire an HR consultant. There are a lot of really great resources online from the Department of Industrial Relations. But the other aspect too, where I think that people can do a really great job of protecting themselves, and you brought it up, Vince, is treating people well.
Yeah.
Because the psychological aspect, and that's why I love employment law.
We may not need laws if we could do a better job of that.
And so, both things play a role when I advise, companies, because you have to take both things into consideration. One thing may be technically legal for you to do, but it will not help you retain people. It will affect morale. It will open you up to, this thing that you are trying to do may not technically be illegal, but you could really treat an employee in a way that they felt is unfair.
Yeah.
And that leads them to then call an employment attorney who then will come digging and will find something wrong.
That's right. So let's talk about the HR consultants a little bit, because I've had quite a bit of experience with them. They will not generally, unless they have people on staff, give legal advice. They will give practical, applicable advice that fits within 80% of what we're talking about.
That's correct.
And we still need lawyers too.
I love that. I love that you said that. And I think one of the CEOs, I think it was the CEO of Cliff Bars, said that, a small investment that he did at the very beginning when he started his company, it was maybe a couple $1,000s to hire an attorney to consult and advise him, saved him tens of thousands of dollars in the end. And I really wish people get that attorneys aren't there just for when you have a problem.
Yeah.
Sometimes it's picking up the phone. I've, had multiple calls when it's a small paid consultation, and they call and we talk through a problem. He goes, "Oh my gosh, thank you so much."
So I like that a lot. It's not, so you're going to hire a consultant, right? You're going to pick me for teaching people how to communicate. And you're going to pick Vince for teaching something on your financial statement or your operations, but you're a counselor. In fact, they call you counselor, right? So to counsel, you're not just the anti-business department of an organization. Credit and legal are usually the anti-sales department, right?
Yes.
No, that's not your job. Your job is to protect me from me.
Absolutely.
Right?
Yes.
Well, and then having, so I just think about, as you guys are talking, I think about the many ways that we use our employment attorney. And it's the review of policies. It's the review of our handbook. It's, when I'm in a situation, it's not that I'm expecting the situation is going to go legal. I just want advice on how to handle it appropriately, and it's great. What should my response be? Because I want to, with the intention of making it right for the employee and protecting ourselves at the same time. And so there's many ways. So if I'm throwing any type of advice out to a listener, is absolutely what Scott said, is there's so many ways to use an attorney like Andrea for advisory purposes. I got
a question very specific, because I've heard both sides of this. I practice one, but I've heard the opposite side as well. There are those companies out there, and we're talking about the employee handbook, right? There are those companies out there that purposely avoid writing an employee handbook, because when it's written, you are now doubly responsible for what you say you're going to do. What's your policy and position on, should a company produce a written handbook and distribute that to folks?
Absolutely.
I agree.
Absolutely. Good. Do it. And the purpose of a handbook is twofold. One, just the process of creating the handbook will educate you as the business owner on what the rules are. It should be like your Bible, because when a good employee handbook should be able to help you deal with 90% of the issues that come up day to day in your business. How to treat employees. It teaches you what the rules are. So it's there as a reference. You're not going to remember everything that's in the handbook. When an issue comes up, you have a reference that you can go back to. And then the other thing is also, in the process of creating the handbook, it's not just the legal requirements that are there, but also how you want to run your business, how you want to manage your business.
Part of culture.
Yes.
That's right.
And so this is where I see this all the time. And so this is a great thing for, especially when you brought up people who are just starting businesses or newer entrepreneurs. What happens a lot is people will take the handbook from their former employer that maybe had 50 or 100 employees. And now you are a business with 2 employees. The rules that apply, the laws that apply to a company with 100 employees don't apply to you. So yes, that's where you open yourself up to committing to more than you really have to. And that's why I would recommend, having an attorney work with you on an employee handbook, because at least in California, but also federally, different laws go into effect based on how many employees you have.
Yeah, no question. I think, the handbook conversation is an interesting one, Scott. And I like that you asked that question because I am a believer. I don't care what size your business. If you've got employees, then you should have some semblance of a handbook, because once you expose yourself, and I find this odd that, okay, there is a site, there are resources that the government has. You can go on edd.gov, right? And it pretty much tells you, what you're supposed to follow. But I'm continuously blown away at how many entrepreneurs and business owners actually just don't even do that. Like that's just the simplest of simple things. And then to think that, I'm going to skip having a handbook. Well, what happens is, I feel like that's a little bit like not having a last will and testament or a trust, right? Then you're leaving it to the state, right? So whatever is on that EDD site is what you fall into. So it's not like you don't have a handbook. So now you're just saying, great, if I come up with a situation, I've got hands off. So what I've experienced is a lot of different things where I think you get into what I'd call very shaky territory. So one is like around commissions, for example. The new law that I'd like to hear from you, and I'd like your feedback on this because I don't fully understand it. But the new thing that we're working on is the visibility on job descriptions and making sure that the job descriptions fit the role and responsibility that they're in, because that's going to be a big miss moving forward. And we have to make those clearly available to our employees, and compensation now. So they have to have visibility on market compensation. So that's what was just introduced to us as a business. So we're scrambling a little bit to make sure that, great, do we have all of our job descriptions in place? Do they reflect the actual job? And, do we have access and resources to market compensation so that we can provide that visibility? And we updated our handbook to make sure that reflects that employees have access to that.
So that's the point I wanted to make sure. And then we're going to get to answer the question on the new law. But just because you have something written doesn't mean it can't be or should be revised to fit the circumstances.
Absolutely.
Right? So when a job changes, right? This job used to say, here's what the responsibilities are, and then something needs to be added or deleted. It's okay to update those things.
Yes, absolutely. And you do need to review and update it at least annually. And going back to your point about, some people say, well, we don't want to commit it to paper. It is one part that is correct is that you don't want to commit something to paper that does not reflect how you actually do things.
That's right.
Yeah.
Because that is worse than not having it on paper.
That's right.
But also when you don't have a handbook, and if you do have employees, so employees in California have a right to request a copy of their personnel file. Mm-hmm. If you ever get sued by an employee or there's a claim and they say, well, you didn't comply with the meal breaks and rest break laws. And that's a very common claim.
Right.
You didn't comply with the, paying overtime rates or double time rates. Mm-hmm. One great defense that you have is, well, we did inform employees of their right, and we have it in a handbook, and it's here.
Yeah.
So with as in the legal field, if it's not in writing, it didn't happen. So that's why documentation is so important. And the other thing to remember with emails is emails are Exhibit A. So keep those two things in mind. Bare
minimum, yeah. But I think keeping a proper email, we talk so much about it. I mean, across our communication, and we talk about email etiquette, and we harp on that greatly. And it's a great point that you bring up, because email is written. It's a form of written communication and can be construed as a contract, as far as I'm concerned, and the state recognizes it as that. So if you have that type of exchange, that's your file. And
destroying emails is not an appropriate way to rid yourself of Exhibit A.
That's correct.
No, I mean, just going back to that point, it's just because you don't have something in writing, so then great if you don't. I love what you said. You said it better than I did, which is just in the eyes of law, right? Then, okay, it doesn't exist, right? So yeah, when you're keeping an employee file, you got to have that stuff in writing. Email communication should be appropriate email communication. And then certainly having a handbook, having written policies, having commission agreements, having these types of things in place are only going to benefit you.
And keep in mind, and correct me if I'm wrong here, but the state and federal rules supersede what you have in writing in your handbook. The laws are the laws. Even if you wanted to have a lower standard, you're going to go to the law to find out what's appropriate and what's not.
Well, that is correct when something, so the handbook has two purposes, right? One is the legal rules are in there, and that's correct. That you have to follow the legal standards. And so companies are subject to both the federal standards and your state standards.
Yeah.
And in California, the state standards are higher than the federal standards. Right. So you have to follow whatever the higher, most protective rules are. But on the other side, on the flip side is that on the non-legal standards, there is a part of the handbook that becomes contractual. That's right. You are, if you are promising extra time off, that's why if you get a handbook from a company that's much bigger than you are, and they give all these benefits that you don't have to by law, if you're committing to that in writing in the handbook, you contractually committed to that.
Well, it's interesting. I love this topic and the question that you just brought up, because I believe I'm of course, I'm not an attorney. She knows more. That's why she's here. That being said, as much as I've learned from direct experience and as much as I've dove in so that I'm doing things the right way, there actually is a lot more discretion to the employer than you would think, because I think that's anecdotal when people say, oh, if you're a California corporation, man, you can't really do anything. That's actually not true. And I would argue to the side of having policies and agreements and employee handbooks in place, because the more you define it, the more discretion you're allowed actually as an employer. Now, that's not there are very specific legal things that an employer is obligated toward. That's not what I'm talking about, but I am talking about things like commissions and the way that agreement and the way payouts are when somebody leaves, or the way that, if you're going to severances, for example, and things like that, benefits that you offer within the company and things, you have to spell those out, because if you don't spell those out, then that's when you're leaving yourself exposed.
That's true.
Yeah.
Because then there's an expectation, and it falls on what you do for one. If you're not doing it for everybody else, it's not equitable. Right now, California is going to say, hey, you didn't have it spelled out. So,
and these are the standards that you had set with previous employees.
Yeah.
They apply.
Yeah.
Right.
That's exactly right.
Okay.
And I would, to that point, I think the overarching theme that I see on the non-legal side when advising, clients is about consistency and setting standards, having a mutual understanding. And I see that all the time, especially with commission agreements, is that things are not laid out clearly. And this is one thing that I would recommend with, whatever commission agreements, bonus agreements, anything that you have, related to how pay, because pay is really important to people. That's important. That's the main reason why they work for you. Have examples.
Not my smile.
Maybe mine.
Okay.
I don't know about yours.
Definitely not mine.
True statement.
But having examples is really, really helpful. That's, when I draft commission agreements, I always go, okay, how does what the landmarks are? Yeah. When is it earned? How is it calculated? When is it paid out? And give lots of examples because that will make it clear. So like a sample report inside the employee manual? I would say it's not this would not be in the handbook. Say outside. Commission agreements are supposed, in California, they have to be in writing. And I would always create them as a separate agreement because they are important. Don't let them get lost in a handbook.
Yeah.
Okay.
So what I would do is I would give specific examples. This person made this sale to, a new client, and this was how much. This is the commission that was earned. But they made a sale, then that same client, because sometimes repeat business gets a different commission percentage, right? Mm-hmm. So I would say that same client came back and they got a new contract. On that one, this is how it would be calculated. And give specific examples because that makes it clear and the employee understands as they're doing the work, and they can have an understanding as to how they would be paid. Because two things, overarching themes that I always talk about is don't let anything be a surprise, whether it comes to terminations, when it comes to pay, when it comes to pay at the end of the employment. Don't let anything be a surprise to the employee. And the other thing is consistency. Because perception is reality. And if you are treating different people differently, you may not have a discriminatory intent, but stories can be told and, facts can be shaped in a certain way to tell a certain story.
Yeah, I think it's funny you bring all that up too, because I think I started to think of travel policy, right? And reimbursement. And getting into, I think there can be gray if you don't spell it out within a travel policy. So we've chosen to put that in the employee handbook. I know other companies that have different travel arrangements with those that are eligible for that, right? Which would be like an outside sales rep. So that goes in line with a commission agreement. We've chosen to have that travel policy in there just in case, hey, there might be a certain employee that might not be in sales that we asked to go do something and we want it spelled out, how you're reimbursed, what that per diem is and all of that. So again, I go back to there is discretion, right, in that. And the state allows for that, especially if you spell it out, right? And it's in an employee handbook, employees see it, they sign it, and everything has been acknowledged so that, if push comes to shove, you can say, hey, here's our policy. We've made it very clear. It's clearly stated. There are requirements that the state has. So I'm not saying, again, those that there are obligations that you need to hold to. But I think there are things. So like the example that comes to mind is mileage, right? You don't have to pay the state's mileage rate. So there is some discretion on that. That's my understanding. You tell me if you know better or not. We actually pay whatever the state mileage rate is,
IRS.
Which is just the IRS rate, like whatever that is. That's what we pay out. But you can do car allowances in lieu of that. You can do other things. But again, if it's not, to me, the only reason I'm bringing that up is like, if it's not spelled out, I believe you're leaving yourself exposed.
That's true. And, to that point, sorry to.
That's okay. I'm going to change gears once I get a chance.
On the reimbursement, the IRS rate is usually a safe one because it's kind of a nebulous standard to reasonably reimburse the employee for the expenses. But one thing that I would like to bring up, because it is a big area of exposure these days, especially post-COVID, with people working remotely on expense reimbursements, is that California requires you to reimburse employees for their cell phone use. And also, if they're using their personal computer at home
Wi-Fi.
To do work and the Wi-Fi. Yes. And I have spoken to class action attorneys who specifically are looking for people to call them about, working remotely and not being reimbursed for using their personal Wi-Fi.
Yep.
That's great. So I'm going to switch gears. I'm going to talk about post-employment contracts tied to severance. You won't sue me if I give you this amount of severance. What's the status? What's the legality? How do we play that game?
The releases. So let me first, I should have given this disclaimer at the very beginning, but we're just talking as educational. I'm not giving legal advice. I'm not your lawyer. Unless I am your lawyer, then I am your lawyer. But so severance, there is no requirement that you provide a severance to an employee when they leave, unless sometimes especially executives, will pre-negotiate severances when they sign.
If it's contractual.
Yes, if it's contractual.
Right.
Mm-hmm.
But other than that, the reason that companies pay out severances is to essentially buy that peace of mind, and they buy that release. Yep. And the release essentially is that, yes, there is a potential dispute as to, what may come up. And so, yes, you can definitely provide a severance in exchange for a release that you will not sue the company.
Good.
Yeah. Can we leave it at that and move on from the severance conversation?
Yes.
I feel like I don't even want to go down that road.
Okay. I like that road. I'm not firing anybody.
And, talking about firing people, I would say that the two times when companies have the highest exposure is one, when you're growing, and that's when you're hiring. And when you're firing. So when you're shrinking, and especially in this economy, I think as industries, and I've been through the Great Recession. I was already practicing law then.
Yeah. Happy, stable employees don't sue you.
Yes, that's
what you're
true.
saying.
That is true. And so, with what's coming up, I can definitely see more lawsuits coming down the pipe, because people are getting laid off, and how companies, and I would love to get this, information out, is how you can protect yourself. If you're going to be going through a layoff, or you are going to be getting rid of employees, do your employment practices audit. Get your stuff in order so that you can look through and go and understand before you're letting people go if you potentially may have, missed meal breaks and rest breaks. Maybe you weren't compliant. You can fix that all before you let people go. Mm-hmm. And that would allow you to be able to protect yourself or defend yourself if anybody comes back.
So if we've been missing meals, the breaks and all that, are we allowed to compensate them for that, or give them the time for that? Or is it their choice on what they get?
No, the law is really clear on meal breaks and rest breaks. There are requirements as to when employees are entitled to paid rest breaks and unpaid meal breaks. And if you the companies have an obligation to, to make it available, but not necessarily to police it.
Okay.
Which then makes it very difficult, because you're like, okay, well, you missed it. I don't have to police it, but you missed it. What do I do about that? But if, for example, an employee's schedule is such that they were not able to take their meal break before the end of the 5th hour, for example, the company must pay a meal break penalty of an hour's worth of pay.
Okay.
And this applies to non-exempt employees. So that goes to the job description, which will help figure out if somebody's an exempt or a non-exempt employee.
Yeah. All those details. I mean, it's attention to a lot of detail. I would sum it up a lot simpler. I think you articulated that perfectly. I would sum it up is, if you're going, especially now, this is very relevant. If you're going through a layoff, or you anticipate that you're going to have a layoff, hire an attorney like Andrea to advise you through the process. And each individual is going to be slightly different. And so I think you can't just simply blanket it out and go, this is what we're going to give everybody. This is how we're going to do it. All that. I've learned from that, because I've had several of those over the years of owning multiple businesses. And best money spent was having an employment attorney on our side that was advising us through the process.
Well, more than that, the employees know that you have the attorney advising you, and probably going to make that assumption that you're following the rules that you're supposed to be.
Well, we're transparent about that.
Right.
Yeah, no, I'm very transparent that with employees that we have that, and that's a resource that's available to us in their favor. I mean, it's good for them as it is for the company that we're doing things the right way.
So besides wage and hour commission kind of problems and meals and breaks problems, what's the most frequent lawsuit that happens against the employer?
Discrimination. Yes. Discrimination issues, and especially with reasonably accommodating employees who have disabilities. Mm-hmm. That may be physical disabilities or mental disabilities as well. And at least in California, there are two separate obligations. One is to do what they call engaging in the interactive process. And that actually is just having the conversation with the employee to figure out what the restrictions are, how to allow employees to be able to work with.
What do you need? How can I help?
Yes,
Very
exactly.
simple, right?
And it's having that conversation is actually an obligation.
Yeah.
And then the other part of it is actually accommodating employees who have disability. So that is definitely one of the most common wage and hour issues. And
pregnancy listed as a disability then. So that becomes a big issue for folks on the time off. And there's all the FMLA and all that kind of things are laid out. But that's an issue that especially small companies make assumptions rather than doing the research and talking to the affected person.
Yes.
Right?
And this year, I mean, it's, CFRA, the California Family Rights Act applies to companies with 5 or more employees. So for a really long time, it applied to, companies with 20 or more employees. And so, is the entrepreneur
that has 4 people considered the 5th employee? And does that kick it in as the entrepreneur?
Absolutely. And people forget that.
That a employee of their business.
Yes, that a corporation is a separate entity. Yeah. You as the entrepreneur works for the corporation.
Yeah, 100%. Scott, we're hitting time.
We do that. We do that often.
Yeah,
especially when we have a guest.
And I'll tell you, like this is a hot topic. I mean, it really is. And there's so many things that we could go over. I'd love to sum it up in one way, because it refers back to our previous podcast episode. And I think, if you go in with the mindset of just treating your people right, I mean, Scott and I are big believers in people. We run people businesses. We think people are the lifeblood of a business. And I think we strive to treat people right. And I think if you go into it with that, you're already a step ahead of it. You're already avoiding, because I think, Scott, you said it earlier, it's just that happy people, aren't litigating. Right. They're not out there, and there aren't issues in those type of separations and whatever happens. And I think if you're open and transparent and just talking through it, it's okay. We talk a lot about psychological safety, and I try to create an environment in my business where employees can come ask questions. They are free to come and say, hey, I want to understand my benefits better. I want to understand the handbook better. I want to understand what's available to me, and to be able to have that. I mean, it's just, and again, so if you don't have that in writing, if you don't have these policies and agreements that are in place, I think you're completely leaving yourself exposed. Those are to your benefit, and more importantly, to the employee's benefit, to have those things in place so that you have a clear understanding of what's available to them. So I personally believe that level of transparency and empowerment and psychological safety creates a really good environment that protects both you and the employee. So I think that's what's critical. And then in the end, my big takeaway here is you got to have someone like Andrea on your side, on your team. You've got to have an employment attorney that is there and available,
living it, breathing it, understands it.
Well, and not just when there's trouble, but to advise. Right. Yes. To advise. I think that's what's really critical. Last words from you guys.
So if you go first, I'll wrap up here, because I have something I really want to say.
So what would be, traditionally, what's a key takeaway? So in other words, if you had to give somebody advice, a listener advice, like they do this tomorrow, what is that?
Have an employment attorney that you can pick up the phone and call, because prevention is the best medicine.
Says the employment attorney.
There you go. So my point to the entrepreneurs out there is that we spend a lot of time worrying about our customers. An unhappy customer will leave. An unhappy employee will sue. The unhappy employee can put you out of business. You can replace a customer. So this stuff's important. It's much more important than I took serious when I was a young entrepreneur. It is the number one thing, that your people first approach will help.
Andrea, please repeat how people can get a hold of you.
You can reach me at AP@Andrea Paris, like the city in France, law.com.
Awesome. You
can always get in touch with us. We can get in touch with her as well.
Thank you for having me.
No, thanks for being on.
This is good.
Hot topic. Love it. Really, really, really great. Okay, guys, thanks for listening. We appreciate you as always. Until next time, cheers.
Thank you.
Thank you.
Thank you for joining us for the CEO Podcast. please visit us at theceopodcast.net, where you can learn more about our co-hosts and listen to past episodes. If you would like to have a discussion and dive deeper into any topic, there is also an option to contact Scott or Vince to schedule some time with them. Thanks for listening.